Waltham they had,
I'm live now.
honoring him, and they
Yeah.
allowed the public to come
Boy, it
in.
must have been packed.
Oh, I imagine.
Oh, God.
I think we're about to go live.
Are we live?
Yes.
Okay. Welcome, folks. This is Joint Justice Oversight Committee, and this is one of our last meetings. We have one more meeting, which is a week from today. It'll be our last meeting before the session begins. And before we go into our agenda this morning, we have a very special person with us, so he's on Zoom. Our former interim Commissioner Baker, though we always refer to you as Commissioner. We wanted to take this opportunity, Jim, to really give you our heartfelt thank you for coming in at a time when corrections was, let's say, not in a good place. There were a lot of pressures, not just from the press and not just from advocates and legislators, but also internally within DOC. And you were called on to help straighten the ship or stabilize the ship. And you did your duty and have given back to the state of Vermont and given back hope to people, particularly people who are incarcerated and our staff within our facilities and within our field offices as well as central office. And I want to say from the bottom of my heart, thank you for what you have done, because you have put in place a path for DOC to reimagine itself and to deliver services to our most needed and vulnerable Vermonters and to take care of our staff as well. So thank you for what you have done.
Thank you, Madam Chair. Thank you.
And other folks may want to speak.
Well, I just commented, and I've known Jim for years, back when he was just a trooper with long hair, doing undercover work, believe it or not. The long hair always got me. But Jim, I think exemplifies professionalism in everything he's ever done. And I'm so appreciative of being able to call him a friend. But I think one of the areas that last January, when after the good time bill passed and we needed to make some changes because of the victims outcry, I can't tell you how helpful Jim was in talking with some of the victims' families of some of the most serious crimes that ever occurred in the state of Vermont. And, you know, having that talent to be able to do that, his ideal of paying it back and paying it forward with the work for people who work in police, corrections, EMTs, etc. Those will go on as a legacy of Jim Baker. And I appreciate having known you and the work you've done. So thank you, Jim.
Thank you, Senator. It's kind words. Thank you. I appreciate that.
Any other folks? I know we speak, both Senator Sears and myself, Jim, speak for all of us here in this room and all of the members sitting around this table. You made our work as legislators a lot easier. I can say that.
Well, I as people that know me well, I often say it's not about me, and it's always hard for me to sit and have people say incredibly kind words, but I really do appreciate it. Representative Edmonds, going back to your point, and Senator Sears' service to the state of Vermont. You know, I grew up in a family where I was taught the importance of public service. You know, my dad was involved in local politics for years and taught me very valuable lessons about what it meant to be a public servant serving the public. And at the end of the day, it wasn't about me, and he taught me that, that it's about the people you serve. And so in this job, as you know, who you serve is can change hour to hour, and you have to be flexible. And the other points that were made, and I want to reemphasize why it's so uncomfortable for me to hear praise, is that the people that I was blessed to lead inside corrections are some of the most dynamic, caring, empathetic people that I've ever met in my life. As I had a chance to visit with people one-on-one through these 22 months, over and over again, they would tell me stories about the lives of individuals that they impacted through their work. And I think that got lost in a lot of controversy prior to me getting here. And as I've often said to the staff, it's easy for a story to run in a news outlet, but it's important that corrections tells its story, and it's a story that's incredible. When you see the work that's done inside, that's not even counting the work that was done in COVID. What the staff did to step up, and I know they're not out of it yet. No, they're still battling it now. But what the staff did in putting themselves in harm's way every single day to make sure the facilities were kept safe was incredible to watch. And so I appreciate your kind words. And you know, I am looking forward to some downtime. I didn't sign up for 22 months. I signed up for 4 months. But I wish I could stay longer. But the time is right, and it is time for me to move on. And I'm going to look back on this experience as a time that I learned a whole bunch about the other part of the justice system that I had no idea about. And I will take that with me. And as I told staff in a message I put out in video, I've met people in this department that have changed my life in my outlook on life. And for that, I will always be appreciative. And I thank all of you for the support. I know at times it was tough. We had to work through some really tough issues. And I appreciate the fact that I was always welcomed in front of this committee and the other committees at the State House. So with that, I do want to introduce the new commissioner. Nick DeMel is there with you. And I simply want to say that I've had the opportunity and the pleasure to spend a considerable amount of time with the commissioner one-on-one. I've given him the 10,000 foot view. I know staff has loaded them up with briefing books and talking about the various components inside corrections. And the good news is, I think this is day 5, if I'm not mistaken, Commissioner. And I see you on video, and I don't see you at the airport getting back on a plane to go back to DC. So day 5, you're still here. That's good news. And it's good news for me. So with that, I'm going to turn it over to the Commissioner, Madam Chair.
That sounds great. Welcome, Commissioner. How do you pronounce your last name? DeMel?
Demel, but interpretive pronunciations and spellings, it turns out, are welcome. For being 4 letters long, people really seem to struggle. It's missing a vowel, I think.
Yeah, that's what it is. DeMel, right?
Demo.
Demo. But I'm going to call you Nick.
Just say Commissioner.
Commissioner. So welcome, and I don't know if you want to share anything with us or
Yeah, sure.
whatever, come on up to the hot seat. And we are now doing a hybrid way of running our legislative committees. This is all brand new to our process. In the past, we did not have a TV monitor screen. We did not have a screen in front of you or cameras or any of it. So this is all new for all of us. So we're learning as we go. When the legislature starts and we get back into our respective committee rooms, wherever that may be in this building, every committee room is going to have a TV monitor with cameras. The microphones are very, very sensitive. They pick up a lot. So this is a new world for us, and it's a new world for you, I'm sure, being in Vermont. But welcome.
Yeah, thank you very much. If you'll permit me a minute before I do an introduction for myself, I would like to reiterate some of the things that you all were saying about Commissioner Baker. I would never say that I am the same caliber of person that Jim is, but it's something that I hope to be, I hope to strive to be in my life. But I do think we are like-minded on a lot of the topics that we've discussed relating to corrections. And he's walked me through, and some others in the government have walked me through, just the amazing things that he's done in the last 22 months with this department. And I hope to carry on that legacy and build on the progress that he's made. And I'd just like to personally thank him for his warm welcome, his education over the last several weeks, and this week, helping me to get through. He said it's day 5. I think maybe technically we started on Sunday with some COVID related topics. So maybe it's day 6, but it's been a wonderful week, really interesting week. And it was made really easy for me by Commissioner Baker. And so I wanted to extend my own personal thanks to him in this public forum. And I told him that in person too, but thank you, sir. It's been, I'm really honored to take over from you. I'd be happy to dig into any part of my background or history or views on the department that you think are worthy or appropriate either now or in the future. But I'll simply give you a brief introduction to me. My name is Nick Dimmel, as we covered at the top. I am a Vermonter for the last about 4 years, I think. My wife and I live in Heinsberg with a small child, so since you're a parent, I can commiserate with what you're going through right now. I've been there myself. But for the last 11 years or so, I've been commuting either from DC or living in DC before taking on this job. I was an intelligence officer with the Central Intelligence Agency, and before that, I was a staffer in the United States Senate on a couple of different topics. And before that, I was in law school. So it's a unique background, I think, for somebody coming into this role, but I hope to leverage that experience of managing really complex enterprises here in the DOC. And I think what I've told staff this week is a lot of the problems or a lot of the challenges I think faced by the DOC are problems or challenges we faced in the federal government too. And so I think I can bring some of that experience to bear. Having said all that, I was really impressed and amazed to find such a high caliber of staff at DOC when I started. And so I certainly will lean on them to help me through, including today in the testimony. But I'll pause it there and just say thank you for having me. I'm excited to get started here, to get to know all of you. And thank you.
Questions? Comments?
Welcome. Yeah, welcome.
Yeah, well,
And one thing, it just came to my attention that I know someone in your family.
Is that right?
Yeah,
It's a big family. Which one are you?
your father-in-law.
Okay, yeah.
In fact, he was a member of the House.
He was, yeah.
He and I were on the same committee.
Okay.
So if you want to know about me, just ask him.
Okay. I mean, yeah, I think he's well known in the state. And
It's a former Secretary of the Agency of Agriculture, Chuck Ross.
Oh,
Yeah, and he was a legislator from Heinsberg,
that's right, yeah.
and he served on Natural Resources Committee with me way back. It must have been the
yeah,
90s.
I remember Chuck.
And I remember he has two, did he have 2 children?
He has 3 children total. Yeah.
Yeah, and I remember when 2 of them were born.
Yeah. One of those is my wife.
Well,
Wow.
So I'm dating myself.
it's a small world. I didn't
is.
realize Chuck Ross. Yeah.
Yeah,
Yeah, I served with Chuck, and he also didn't he work for Senator Leahy as well?
yes.
Yeah, he was the state director here for 20 years or so.
Yeah.
Yeah, that's the beauty of Vermont. I mean, this is what is so precious about our
Yeah.
state. It's so precious. And we're so fortunate.
Yeah.
And so when you see him, just say hi.
I will, absolutely. I'm sure he'll be excited to hear that. I know he really enjoyed his time in the legislature.
Yeah, that's great. Okay, yeah, so we're gonna transition to our agenda. I don't know if you're gonna lead it or we're talking about Rule 74 and I think we need a little introduction of Rule 74. And it was in our bill that dealt, it was S 338, I believe, last session, dealing with the courts and DOC, and I'm trying to recall exactly, is it
Well, the appeal process.
the appeal process?
And which rule to use. And
Right, and that, so if we could, someone could lay the groundwork of that, of Rule 74, and then there are some issues occurring with it.
I'm gonna turn it over to our experts so that you actually get accurate information. I'm not just making it up on the fly, so, I don't know if Emily or Al wants to come up and do the introduction. Thank you again.
Thank you. Welcome.
Good morning.
Good morning.
I'm Emily Carr, General Counsel for the Vermont Department of Corrections. So Rule 74 is an avenue in which, if it's in statute, someone can appeal a decision made by the government. And during the last session, under 28 BSA Section 724, this is with regard to community supervision furlough. The legislature allowed for certain DOC decisions to be appealed using Rule 74. Those decisions, as DOC understands it, were for those whose furlough, community service furlough, who were interrupted or revoked for 90 days or longer for technical violation only, and after the statute was effective, which was January 1st, 2021. Is now what we're seeing, many different case staffing decisions being appealed. And the way Rule 74 works, we have a clerk, we had to designate a full-time employee to be our Rule 74 clerk, because the appeals are filed with that person, the clerk, and the clerk was responsible for filing them with the court. And then the department has 30 days to collect the record and file that with the court. So what is happening is we have about currently 50 or 60 cases pending, but also another 50 cases or so in the process of being filed with the court. So court, field staff are collecting the record, which sometimes consists up to 400 pages. We had a case, it's 126 pages, so it's a lot of, it's a heavy lift on DOC staff. But the most important thing that I think I would like you to focus on is the fact that we're having people appeal prior to 2021. We just got an appeal for an individual challenging it's a decision the department made in 2017. People are also challenging programming decisions the department has made and classification decisions the department has made. And courts are also inconsistent in the way that they're handling these. Some courts are screening them out down in Rutland Superior, saying, you know, this is insufficient. File another appeal with sufficient facts that meet these criteria. Washington Superior is not doing that, so it seems like a lot of them are funneling the cases through Washington Superior. So a lot of this we need to work out with the courts, but I think what the department is asking if maybe we could have better language in the statute to make it clear as to exactly what type of decisions can be appealed under Rule 74. It's clear to me, but not for the incarcerated individual, and the advocates, I think, are also pushing to kind of broaden that criteria.
So you stated that there's 50 that are already been filed, and there's 50 in the pipeline. Of those 100, how many of them are for situations that is not covered by statute?
Yes, so I don't know the exact number, but I can tell you on average, the department is revoking or interrupting about 5 individuals for 90 days or longer a week. And our clerk is getting about 14 appeals a week.
It's almost a third.
Yeah,
That's just legit, and 2/3 that, so I'm wondering if the issue that's really driving these requests is that people are feeling their grievances have not been addressed. And this is another avenue, particularly for situations that may have occurred in 2017 or 18 or 19 prior to the law going into effect in July. I'm just wondering if there's a feeling from the folks that, hey, my grievance wasn't taken care of the way I wanted it to be, or it's not going through the process, so I'm going to use this process.
well, I can tell you that I do see grievances coming through and they are getting responded to. I can understand when the individual is not getting the response that they want the department to change its mind. So yes, they're like, oh, maybe I'll try it this way, but it's not the proper way to do it. Some of these decisions can be filed as Rule 75s, and there's some case law that might not support the department's decision being overturned, but there's a different avenue for those types of decisions to be challenged. There's also time limitations though for Rule 75. It's a 30-day time limitation as well.
Questions? Teresa, and then Maxine.
So this is new to me, so apologize if the question is, seems simple. So for things that seem obvious in terms of Rule 74 not applying. So there's no just simple way to say, sorry, this doesn't apply.
I think some courts could do that, but some are not. And when we get the appeal, we don't know what the court is going to do. And the department has 30 days to file the record. So we're not in default. We're collecting that record and sending it along to the courts. Our AAGs could try to file dispositive motions, but they can't do that until the record is complete. So like I said, we have some decisions from Judge Tor in Rutland Superior, and she has screened them and said this doesn't apply or I need more information. But some courts are just letting everything kind of go through. There has been status conferences on a few cases. Judge Mello is trying to narrow that scope a little bit.
So the procedure is that the request goes directly from the incarcerated individual or their representative to the court and then to you?
It's supposed to be filed to the DOC clerk, and then our DOC clerk is supposed to file it with the court.
And so the DOC clerk can't say upon review that this is not eligible.
Correct.
They don't have the authority to do that?
Correct.
Maxine?
Yeah, thank you for your testimony. How many individuals are represented by the Prisoners' Rights Office?
Oh, I wish I had that number.
In these circumstances?
Yes, I wish I had that number. I think a majority of them, and I think initially Prisoners' Rights does step in, and sometimes if Prisoners' Rights doesn't think that they have a legitimate issue, they'll withdraw, and then that leaves the individual representing themselves. But I don't have that number. Typically, it's, in my experience, Prisoners' Rights represents a majority of the individuals who file cases.
And have you had the opportunity to discuss this issue?
With Prisoners' Rights?
Yeah.
We met earlier in the summer. Myself and our clerk met with one of the attorneys to try to figure it out. And we even sent a letter to Judge Gerson, but there were a few issues we just had to agree to disagree.
Yeah, thank you.
What?
Thanks.
So was the S 338 not clear? I noticed your last bullet point was to clarify the language in the bill of who and when somebody could appeal that decision. Were we as a legislature not clear on what we had intended, who should be available for the opportunity of that? Were we not clear enough, or did we just trip?
As witnessing the testimony during the passage of this legislation, it seems to be clear to me. But I think, like I mentioned before, it's not very clear to those who weren't part of that discussion, who don't have a legal background, and also advocates maybe just trying to find a loophole. So just making the language extra clear, like if you, in subsection C, if you specified right at the get-go, community supervision, furlough, technical violation, 90 days or longer interrupt or revocation, and that occurred after January 1st, 2021. I think that would help. Another issue with regard to testimony, I think that's what I noted in my last bullet, is that the appellant is able to testify, but we're finding that the department has been able to present witnesses to testify about our policies, but not about the facts of the case as well. So it would be helpful if that language is clarified.
I'm just reading over the law that we passed.
Yeah.
I thought it was pretty clear. We wanted to avoid as much as possible technical violations of more than 90 days for that did not constitute a new crime. So what we put in the statute was the offender's risk to reoffend can no longer be adequately controlled in the community, and no other method of control of noncompliance is suitable, or the violation or pattern of violations indicate the offender poses a danger to others or to the community, or poses a threat to abscond or escape from furlough. I don't know how much clearer you can be, but I've found lately, I kept reading over the youthful offender law that we passed in 2018, and I don't think the courts or somebody is interpreting it properly, because I think that's clear. You know, we don't want you violating people's, furlough if it's going to be 90 days. We had a lot of discussion about whether it should be 60 days or 90 days, if you remember.
Yes.
And I think at one point it was 60, at another point it was 90, we settled on 90. And so I'm happy to support the department in changes to clarify, because I think we were pretty clear, Butch, in what we really meant. And I don't know how the courts do some of this stuff, frankly, because it's, you have risk assessments that I think are, maybe that's one thing we could put in there, risk assessment indicates. But, I'm sure that's part of what you're doing. So, I don't know. It's just really discouraging to see this drawn in like this, as if we didn't know what we were doing. And this was all part of justice reinvestment too. And we work closely with the lawyers and folks on our side, as well as those people from the Justice Center in drafting all this. So it bothers me, and I will once again say that I think it's clear, but I'm willing to help in any way to make it clearer.
And I'm wondering if to get to that, because that's where I'm coming down to, but I'm wondering, because in reading your testimony, it seems like entities just aren't talking to each other. And I'm wondering if part of clarifying the language, which whatever needs to be done legislatively we can do, but prior to that the parties really sit down and figure this out.
Yes,
So that we don't waste committee time trying to figure it out. This has to get done prior to a legislation being worked on. That, you know, we've got the prisoners' rights, we've got the courts, we've got DOC, and then any of the other advocates. And I would request that everyone sits down and figure out where are the problems and start putting a policy or start putting something in place to address that. And then that may really clarify what language needs to be clarified in the statute.
I agree, and I'm happy to get that group together to try to.
I would almost make that a requirement. I don't know where other folks are on this committee, but I think the parties need to sit down and figure it out.
Yeah, I was just gonna say, when I look at the suggested fixes and what you're seeking, these look like administrative fixes to me. They don't look like statute fixes mostly. I mean,
Yes.
they seem to be procedural issues, some of them. And it seems as though the list could be whittled down to something that might be, if you have something like very specific. But I agree with the senator and the chair about this.
Yeah, I mean, let's clarify whatever language for definition that we need to, but let's see if we can try to correct the process and see where the real issues lie. I mean, it seems like one part that I picked up was that the Prisoners' Rights Office forms just don't seem to be, appropriate, or they're pretty, sparse, and do not provide all the information the courts needs.
Yes,
Talk to each other and figure it out.
and I did reach out to Prisoners' Rights asking if they could at least on their form put that the decision was just not a case staffing decision, but it was a case staffing decision regarding community supervision furlough. And the response I received back was, I will talk with my office, and I haven't heard back.
It's not all DOC here. I mean, the other part, the courts are split on following Rule 74.
Right.
Filing time.
But the courts put together a form that they want to see.
And they have been before. I mean,
Right.
it was,
Well, we
we spent
started
a
with
lot
Rule
of time on,
75.
right.
We started with Rule 75 on
Yeah.
this, and then it got changed to Rule 74.
Yeah.
And, go ahead.
Yeah, do we have time in the next meeting's agenda to hear from the court
We do.
and prisoners' rights?
Yeah, we should have it here too.
I think, if I can jump in, I think you do probably have some time on the next schedule, and I think that's an excellent thing, because I think you guys have all hit on it, which is, I think it's a coordination of administrative rather than looking at the staff.
And ask the three of you to sit down before this. And maybe we can resolve this without.
So I'm not confused, just concerned when I hear Emily speak about parole revocations predating the enactment of the law. And what was our intent? We're going to take a look back for 5 years, 10 years, 1 year, or I was understanding that it would be effective January 1. Am I wrong on that?
Usually what happens when there's a change in like good time, it's prospective.
Mhm.
It's when the effective date of the statute, and then when those folks fall under that going forward, that statute would apply, but it's not retroactive.
So it makes me wonder, why are we getting those requests from revocations prior to enactment of?
That was my question too, Butch. It just seemed like,
That's why I asked the question, is that the grievances aren't being resolved, or there's other issues, and then they're using this avenue as a way.
So we didn't put a date certain in the language, but we believe we made the assumption that would be upon passage,
Right.
well, it says effective January 1, 20.
January 1, yeah.
I mean, that there is an effective date in here.
But where's the confusion?
And we passed it in 2019, and we wanted some time to set up the process, and the furloughs were changing, and to let that all settle in before we put this piece in. So would it be possible for what Senator Sears mentioned, that prisoners' rights, the courts and DOC could sit down this coming week prior to our next meeting, which is next Friday?
I will do my best to arrange that. And I really appreciate y'all hearing us out. It's just, it turned into something that we weren't expecting.
Mhm.
It just meant to update you on that.
But DOC's getting the brunt of it, but you're not the ones that are making all the decisions or some of the problems.
There's something else that
Yeah, there's something else going on.
Representative Emmons, can I ask a question?
Sure, go ahead.
Yeah, thank you. I'm not as familiar with any of this as those of you who have been on institutions or judiciary. But it seems to me that I don't know, but is part of the problem the way records are kept and the communication system that's currently in place with judiciary? Is there an electronic data set? Is this information held only in paper files, and communication between DOC and judiciary paper? Is there electronic? Can some of the data be sorted? And then my last question is there any funding, federal or others, that might be able to close a gap in a system that is paper rather than electronic? And would that help? I mean, I can't answer that. You can.
You follow that a little bit. Is it more, Jenny, are you kind of looking at with the new case management system in the courts, if there is some issues between all the other systems coordinating and communicating
Yes,
electronically?
yes. I mean, is all of that, is it all being collected electronically? That's the first question. And then is there a link between DOC and judiciary that doesn't have technical glitches? And then how is it used over time? I mean, how is that information archived or pulled out for comparative analysis, if that's appropriate, case by case? I don't know.
So I do know our clerk uploads all the record into Odyssey. I do know that her name is also entered in all the cases that are filed, so she can go in and search her name and pull up all the cases, but I think you would have to open each complaint or each notice of appeal to figure out what exactly they're appealing, what case staffing decision they are appealing. So it would be a little difficult to figure out if they're eligible or ineligible Rule 74 cases that have been filed without a little bit of extra manpower.
Thank you.
Any other questions? Comments? Well, if you could, with your commissioner, I would have to come from the commissioner, not just you, would be asking a lot, to really connect with the court administrator and prisoners' rights office and some of the other advocates, and maybe you've been working with, to really find out where's the administrative issues here and see if we can resolve that. We are going to be meeting next week on Friday the 12th, so you're on a really short time frame, and we'll schedule folks as well to testify next Friday.
Sounds good.
See if we can get a direction here.
Yes.
Thank you, and welcome to a new position for you.
Thank you very much.
Oh, it's a heavy lift. Thank you. Okay, our next issue, the largest issue we've been working with is expungement and trying to make a recommendation. This is one of the requirements of this committee, to really make a recommendation to the legislature about how we move forward with expungement, sealing of records. Do we have a 2-track system, a 1-track system? I know the 2 chairs of the judiciary committees have been working hard on this, and there is a document from Michelle Childs on our webpage. So Michelle, if you could come up. Thank you, folks from DSC, for coming in.
Thank you very much.
And we'll be seeing a lot more of you folks come January.
Looking forward to it.
Thank you. Welcome, Michelle.
So I just want to say, and I'll work it out and make sure you guys have staffing, but I didn't ever get notice of Friday's meeting, so I don't have a meeting notice or anything about that, so I'm not sure. I'm actually not in town next week, so, but I'll make sure you guys have what you need
That's coverage.
based
Yeah.
on whatever.
Because that was an extra meeting
Right.
and we did have approval to meet, so they did fall through the cracks to get
Right,
through.
yeah, I think because Thursday's a state holiday, and so I.
Is it?
uh,
Oh, is
say-
it Veterans Day?
It's
It is
Veterans Day,
Veterans
so-
Day, yeah, so.
And my first trip down to New York City in 2 years since COVID, so
Yeah, we'll go.
I'm excited about that.
Yeah.
Yeah,
Um,
yeah, we'll
Okay.
figure something out.
yeah, we'll make it work.
So
So
you
I'm
do have a
gonna,
document.
I'm gonna share my screen. I think I can. Oh, can you allow me to share my screen? It says disabled.
We do have it on our, we can all access it on our iPad.
Is it, would you prefer that instead of doing the screen?
How about you folks?
I would like it on the screen.
Okay.
All right, okay. So for the record, Michelle Childs, Office of Legislative Counsel, and as the chair already mentioned, you know, this has been something that our folks have been working on for quite some time. Judiciary Committee's really deep into the details this past legislative session. But as you saw, based on the, I think, 4 meetings in which we've already talked about this in here, there's so many details, it's really hard, I think, for a committee like this where there's such varied expertise to really go into all the minutiae of details. And so the chairs of judiciary thought that the best approach is, rather than having a bill that has all those little details in there, to have kind of a guidance document for how the legislature proceeds with this type of legislation moving forward. And so I won't go through and read it, but I'll just kind of give you the highlights here. Basically, just, you know, recognizing that, you know, this is something the legislature has been working on for a long time. You've passed a lot of legislation over the last several years, kind of recognizing that criminal records are something that can hold people back from being able to move forward with their lives and employment and other things. And I want to make sure that old records don't unduly hinder someone from being able to do that, but then also taking into account its impact on victims and also on public safety, and making sure that people that may need records in the future have access to them, but under very clearly prescribed circumstances. And so you see the first page has the language that was contained in S7 and your charge that we've been discussing. Page 2 starts and talks about that you have decided to recommend a 1-track system of sealing as opposed to the existing 2-track system. So the 2-track system we have now, you have your eligible offenses, you have some types of records can be expunged, meaning that they are gone completely, and there's no access other than through a special index that, and then the subject of the record can have access to information going through the special index. And then the other alternative is some records can be sealed. And in the case of sealing, there are limited circumstances in which there can be access to those records. The primary one that I think most people have been concerned about is that there's a very broad exception for law enforcement using it for criminal justice purposes. And so,
Madam Chair, I'm sorry,
yes.
Michelle. I'm just to clarify, is this a draft that we are going to read and vote on, or is this a statement of what the committee's position actually is?
That's what was going through my mind too, as we started this.
Because we, as far as I remember, we haven't voted on whether to jettison the 2-track system.
We have not voted on that. We have discussed that that's the direction we wanted to go in, but we did not take any formal votes on this. We did have at our last meeting a draft of a piece of legislation
Yep.
that was getting really into the weeds of the issues that is way beyond the knowledge of this committee. It's really within the two judiciary committees, the House and Senate. So the thinking was, instead of us really working through a legislative draft of a bill, which should really be in those judiciary committees, maybe we make a recommendation.
Right, and
So I think today for this, we need to figure out, is this our recommendation or not? I think it
Okay.
really puts it down on paper. Where are we as a Justice Oversight Committee in our recommendations? I don't think we know where we are at this point, where we are for our recommendations.
Okay, I appreciate that. I'm remembering my concern at the last meeting was that we were divided, some physical, some virtual. It wasn't clear to me who would be voting. And my objection at that point was that I didn't think it should be a bare quorum who would make the decision. Can someone remind me what the House rules are and the Senate rules for voting virtually on something like this? Because I couldn't be there today, but I would hate to not be able to vote on what is actually the determination.
Right. I think the two bodies have different rules. The House, you cannot vote unless you're present. The Senate, you can vote electronically, but I think you need the quorum physically. You don't?
Senate committees can meet. If it's purely Senate or it's a committee that's not operated by the legislature, they can meet and vote remotely. It's only when it's a joint committee of the legislature, because of the House rule, that won't allow people who are remote, like Senator Baruch, to vote. So that's where one of the reasons I came today was because I felt like that rule, that's why I'm Justice Reinvestment too, because it's actually run by the judiciary. We can take votes.
We can take votes because it's not.
And if you're just the Senate, you can vote. But if you're a joint committee of the House and Senate or a House committee, you can't vote remotely. And that was, I believe, a decision made by the Senate secretary and the House clerk.
We did have discussion at our last meeting about needing to be present in order to vote.
Mhm.
And knowing that there was going to be a recommendation by the committee.
But people can certainly voice their objection remotely. I mean, there was one memo that said that people couldn't even participate remotely. They couldn't even discuss things. And I think Senator Lyons and I talked about that. And I remember Senator Lyons, I thought it should just be up to the chair of the committee where the people could participate remotely. It's got a little bit.
Welcome to a crazy world.
Yeah, and nobody knows. I mean,
Nobody
it's
knows.
similar to the stupid rule we just talked about, where the court isn't following legislative intent. Or somebody isn't.
I will, if I could, I'll reserve my comments until Michelle's finished with the draft. My related concern was that I planned to vote in favor of a one-track system if it included certain elements, but not if it didn't include others. So we haven't been through the whole document yet. So it may be that I have no objection. If I do, I'll register it for the record, but won't be able to vote one way or the other, it seems.
So I think that's fair, Phil. Let's go through the memo and see if your concerns have been addressed.
Okay,
And if they haven't, please flag that.
will do.
Okay. So let's continue.
Okay, so continuing on with the memo, I'll just highlight kind of in the middle of the page, explains our current system and the difference between expungement and sealing, and how the determination is made, based on the type of offense, the length of time since the person has successfully completed the sentence, and whether the court finds that whether it's expungement or sealing serves the interest of justice, among some other factors. But everyone, I think, pretty unanimously agrees that the current system is overly complex and hard for folks to, not just for practitioners to navigate, but, folks like I think you've heard from testimony from some of the witnesses that, people who are looking to expunge a record are just really kind of completely overwhelmed about how to try to navigate that system. And that's that's just what happens oftentimes with legislation, which is you piecemeal it and you take little pieces, and an advocate wants something one year and somebody wants something next year. And then once you look at the whole thing, you're like, well, maybe we need to reconsider all of it. And so that's what you've been undertaking. So the committee is recommending that you go to a one-track sealing process that limits most access to records in a manner that's similar to expungement, but we are calling it sealing, noting that you can define sealing however you want. And so I just want to be very clear, and I tried to say it a few times throughout the memo, is that, when we talk about sealing, we're not, we don't want to keep that old idea of sealing in our head, meaning that, there's this broad access by law enforcement to all those records. You're going to say it's going to be sealing, and there's going to be a range of what sealed means. Some are going to be exactly like expungement, and it sounds as though the majority of the committee is looking towards favoring that type for most of the records. But then there will be other types of sealed records where there may be limited access for certain law enforcement purposes, or if the state needs to defend against a lawsuit or things like that. And that's really the stuff that I think the judiciary committees are going to have to dig into deep, because we heard from the witnesses last time, and like with the prosecutors, they came in, but they didn't, and they kind of talked about the exceptions, but they didn't really give us any details about, knowing that you want to scale back that access, what types of specific situations is it important for them to have that information? And so I think that's where you really will have the judiciary committees can have folks in and really kind of drill down into that. And so I noted in there that the scope of the expectations, who has access and under what circumstances, should favor confidentiality and be very fact specific. And that the committee believes that the current access to sealed records by law enforcement is overly broad. So page 3, this is where we get into the types of offenses that are eligible. And again, just as a refresher, I went over some of these last time we met, and these are largely based on the last version of what the House was working on. And so the general gist is that all misdemeanors will be eligible. And anytime I say eligible, that doesn't mean you just get it. There's no automatic in any of this. That's something that hopefully the legislature will be considering in the future, because you have an interest in that, but that we're not quite there yet. But when I say eligible, it means, it just gets you through the first hurdle, like what the previous witness was talking about with Rule 74, saying, well, there's certain things that are coming to court that aren't eligible, right? You got to pass the first test. So all misdemeanors would be eligible except this list here. And, these are the familiar ones to you: listed crimes, sexual exploitation of children, domestic violence types of offenses, things involving interpersonal violence, and those would be accepted and those would not be eligible.
So for this would be all misdemeanors would be eligible except for these listed here, for the record to be sealed.
Yes.
And that would be at the level equivalent to an expungement.
Nope, you haven't defined yet what sealed would be. So we're just saying what gets you through the door for the process.
Okay. And then once you're through that door,
yes,
then you're going to have different levels.
Yes.
Okay. Phil?
Madam Chair, I asked about neglect of duty by a public officer last time. And as I remember, no one really had a memory of why that was included here. It does seem to me to stand out from the others, which are violence or exploitative or, so I looked up that during the last meeting, and it's certainly an offense, but seems to me of a, a sort of, just a different order. I'm just wondering why someone wouldn't be able to seal a conviction for this.
So if I'm understanding your question is, why wouldn't the neglect of duty by a public officer, why is this in the exemption list?
Exactly.
Why isn't this an automatic, it's a misdemeanor and you would qualify?
Yeah, because if,
Governor won.
what was that?
That's what the governor wanted, is my recollection.
Is there a representative of the administration there who could maybe speak to that?
No,
No.
Oh, well, it's,
I mean, there was, in my recollection, Maxine can correct me, but I believe my recollection is that there were certain things that the governor had objections to that were in S7, and that was one of them, because he was concerned that somebody who had embezzled money from the town of whatever would be able to get a
but
record expunged.
Haven't gotten to that section.
And
But I don't think embezzlement would
That's,
be under
that's
neglect
the
of.
financial section down here, but.
no, I know, but that was the public officer neglect of public duty. To my recollection, that was what he was concerned with, and also police officers, wasn't it?
Well, I suppose I'll register an objection, and then when this comes to judiciary, we can dig more into it. But it's a little opaque to me what the reasoning would be, having read that particular statute.
Yeah, no, thank you. And these are our recommendations, and certainly the committees of jurisdiction will need to look at all of this and go through the process, go through the testimony. So I'm not looking at, any of this as an absolute done deal, but it's a starting point in their considerations.
We're sort of, our recommendation was sort of, I want to say lay the groundwork of, okay, our recommend is we go to a one-track system. And we really redefine what sealing of records means. And you have different levels. But what is going to automatically qualify or what is going to be exempted, that level is way beyond the level of this committee, and it really resides in our policy committees to do the deep dive. And we're not going to get into that deep dive. It's just a broad overlay. That's how I'm interpreting it.
So when we read Michelle's document here, according to what's been said, we know that there's going to be the recommendation is all misdemeanors are going to be eligible except a list. I mean, this is just maybe a sample list for now until it gets to the committees of jurisdiction.
That's how I'm interpreting it.
Yeah, and okay.
And because from this list, what Michelle said, this gets you through the door of what would be eligible and what would not be eligible.
Right.
And even though something gets you through the door that you're eligible, doesn't mean you're going to get it. These are not eligible. But we're not making that final determination in statute if that's actually going to happen or not, because that's up to our policy.
Right, and then but we do the opposite with felonies. We're saying most felonies are not included with the exception of a list, and which will be determined later through the session as they work on
Right.
7 or whatever the new number is going to be.
Yep. And also, using the one with neglect of public duty as an example, once you dig down and try to understand why is the administration advocating that those should not be eligible for sealing, once you look at it, it may be that you can accomplish their goal with that by making it eligible, but having a wider access to that information, even though it's sealed. Do you know what I mean? So that it would be sealed from public view, somebody doing an employment check or something like that, but that law enforcement, or, I don't know why or, maybe their reasoning is that they do want the public to know, and they wouldn't want the public, they wouldn't want this person running for chair of the school board if they had, had some other issue in the past and they want that publicly known. And then you have to look at, well, then should it not be an eligible offense? But I think, you can look at these specifically and say, who should be able to know about this conviction, how long ago it was, and, what should the level of access be?
Does that help at all, Phil?
Oh, yeah, I tried to indicate that I was just flagging it, and then we can pick up the blow by blow things on the list in the committees of jurisdiction.
Mhm. I think that's, or at least that would be my intent. I'm not speaking for the whole committee here, but that would be my intent on a recommendation. We don't get into the weeds. We just lay out the broad scope, knowing that the real policy issues will be vetted in our committees.
Okay, I'm gonna keep going. So Butch did a great job explaining the felonies there. So I don't know that there's much more for me to say other than, the default is that all misdemeanors except for a handful, and no felonies except for a handful. And those are the property offenses, the designated property offenses that are in there.
So, Madam Chair, I guess I'm gonna do the same thing that Senator Baruch did. The designated felony property offenses, I feel like that there is, that this is a pretty broad list. And some of these things like stealing a person's identity, while it might not physically, be going in and assaulting a person, I can tell you from constituent experience that it dramatically impacts a person's life, maybe even more than a physical assault does. And so those being eligible, some of these being eligible, I just am flagging it as a problem for me.
Welcome to your work coming January.
And also, and I think, that's really where the real work will come in, because if you'll recall, if you look at like the way the system is now in statute and what legal aid is proposed, there's a tiering, right? To say, so certain offenses might be eligible at 4 years, other offenses won't be eligible until 10 years, and you've had a clear so that you weigh those types of things on impacts and things like that, and then they can go through.
Yeah, I mean, we know from testimony on another bill about this, the home improvement fraud, we had long discussions about that in the House. And, there's a lot of emotion tied up with that in the community for people who've experienced these things. And I think it's going to be a difficult task, let me just say.
Well, but I've looked at this issue as from 2 angles. One is what crimes should be not be able to receive expungement or sealing. But if somebody has gone 10 years without committing any new offense from the time they completed their probation and paid off all their fines and restitution and surcharges, should we hold them back? And the second guide for me has been what is now diverted on a general basis by state's attorneys. Many of these crimes that we hear about go into diversion, and the victim is made whole by the offender through various processes. And I was looking at the number of people who are now diverted versus the number who go to trial on many of these crimes. And it's most of it is diversion. So even the Tamarack program, which is the second time around for offenders. So the state's attorney has a say in usually who gets to be sealed or expunged. Then in the process, there has to be a certain timeline, whether it's 3, 5, or 10. Advocates are constantly trying to get lesser time, but all the records show, all the evidence shows that about 7 years, and this is disputable, but about 7 years after you've gone through, no new offenses, nothing changed, you're no more likely to commit another crime than any member of the general public.
So my thoughts is exactly what Michelle was just talking about when we are thinking about this in terms of legislation, thinking about at what point, do those,
Not that, which means that not everyone who committed home improvement fraud is going to be eligible to have that record expunged or sealed. There are those that have been a certain period of time, whatever that might be, and the state's attorney has said, yeah, they're okay with it, and the victim in many cases.
just pointing out some things that I
know,
are some,
it sums up, and
yeah.
most recent example, I think, was Sirhan and the Kennedy family, and some members of the Kennedy family wanting him to have parole, and other members saying absolutely not. So,
So I did note after the list there that while the committee is not at this moment recommending that most felonies be eligible for sealing, the committee believes that the list should be expanded to most nonviolent felonies eventually, provided that sealing serves the interests of justice and prosecutors continue to be afforded the opportunity to weigh in and have a voice before the court with regard to whether or not sealing is appropriate. And that's because the Senate version had allowed it followed the model for misdemeanors, which said all felonies are eligible except these felonies. And then the House was more scaled back to what you have here, in large part based on the administration's opposition to the Senate version. And so this is kind of going more with what the House's last position was, having a much smaller list of felonies, but indicating that there's a strong interest by the committee in moving towards, continuing to expand, but to do it in a thoughtful way, as long as the procedures are there to make sure that it's appropriate in those felonies.
I was going to say, the other thing that I just want to note is I think it's important for us to recognize, I'm going to look to Trevor here, about the additional workload that this places on the judicial system, when that's something that we heard in testimony as well, that there's, so the notion of there being some that are sort of automatic, like what does really automatic mean, so just keeping in mind, when we make some changes like this, we do sometimes require additional staffing to implement them.
And I do address that a little bit later in the memo.
Yeah, I see that.
So next is that moving to a one-track sealing system, the committee believes that the sealing must be redefined, providing that the vast majority of seal records are confidential to everyone except the subject of the record, and allowing limited access, and asking the committees on judiciary to really get into the specifics there so that we can develop something for statute. And then
Michelle?
the issue at fund.
Madam Chair, I know that, again, committees of jurisdiction will specify these things. I'm wondering if the committee would be agreeable to adding somewhere in this language that we would consider penalties for people who access this higher level of privacy without authority. Because I feel that what we're doing is, by moving to a one-track system, we're removing what was ultimately the guarantee we had promised originally, which was that the records would be destroyed. Now we're saying the records won't be destroyed, but we will, we will work toward making them sealed in the vast majority of cases. I'm not asking for a specific solution here in terms of what the penalty should be, but I'm wondering if we could make a nod in that direction as we've done in these other directions.
I think that's on page 5.
So Philip, that nod is at the top of page 5. I didn't forget you.
Oh, great. Perfect. Thank you, Michelle.
So top of page 5, committee believes there should be something in statute provides for penalties for unauthorized access.
That was quick.
Don't you wish all the victories in committee were this easy?
Yes.
So I wanted to go back to the bottom of page 4 on the automatic sealing. And, this has been an issue that's been kicking around for a while. There's a lot of advocates that are like, oh, people shouldn't have to petition, especially for certain types of offenses. And so what I tried to do was express your support for that concept by taking into consideration things that like Teresa made, which is that, it's complex. And we know that you're dealing with a number of different departments. They have different types of record keeping and IT systems. How do they talk to each other? What types of staffing and financial resources would they need to be able to do it? We know that, again, because the legislature has been working consistently on this issue for a few years and has made changes to it and expanded it. But then with COVID, you also kind of put that stuff on hold because you were prioritizing, and working with the judiciary, how to get through COVID when we had to scale back so many things with regard to the judiciary, and said, okay, let's put these expungements over here because we really need to be dealing with these very important issues of people being able to get access to the courts on appropriate timelines. And so that stuff is really, backed up. And, you can think, for example, of just what we did with cannabis and with the expungement of cannabis convictions, for things that are no longer a crime. And so they are going to be playing catch up for a while on just trying to comply with what you've already asked them to do. And so I wanted to put something in here, just recognizing that you have a strong interest in being able to move towards having some form of automatic expungement for certain types of things where you don't feel as though it's necessary for the prosecution to weigh in. But at this point, just kind of heaping more things on to these folks when they're trying to move through what you've already asked them to do is probably not the most helpful. But I did want to just acknowledge that you do have an interest in that and you want to keep moving in that path. And so, maybe as part of this legislation, as when it's working its way through the standing committees, is really hearing from people about what they think, what's the low hanging fruit, and how could you start out doing something like that, kind of maybe on a trial basis, and seeing how that would work and coordinating with the different agencies and what they would need to be able to do that. And that's it. That's all I have.
Thank you, Michelle. I think you did an amazing job of hours and hours of testimony over like 5 meetings and trying to, put all the disparate viewpoints of everybody together. So
how are the committee members feeling? I mean, I can pick up people are semi-okay here. How are you folks on Zoom? We have 3 senators on Zoom. How are the 3 of you feeling about this recommendation from us to the standing committees? I'm open for anyone to speak up.
Madam Chair,
Yes.
I am very pleased with this draft. I think Michelle did a great job. So if I were there, I would vote yes, but understand that the rules don't allow me to vote one way or the other.
We'll take that to heart, Bill.
Can I add a second to that? I would also, were I there, support this, and the comments that have been made have been really very helpful in allowing for me to support this. So thank you.
And I'd agree with my two colleagues. I think Senator Bruce questions clarified some things for me, and still leaving a lot of the work to the committees of jurisdiction when we return in January. But I would vote yes if I were there.
Butch?
I have a little question for Michelle. I'm having a little trouble following your footnotes at the end of page 4 to where they relate to, or maybe I just missed it during your explanation.
Page 4.
What footnotes on page?
Oh, that's just a continuation of footnote 6. It's
Okay.
just the way
Oh,
that,
Okay.
it,
Formatting, yeah.
formatting handles
Okay,
it. It's
all right.
just I just wanted to make sure because I didn't want to just say designated property fences and people not really know what we were talking about.
Thank you.
Did someone want to say something? It feels like I heard a voice on Zoom. No? So I'm picking up that people are comfortable with this and they're okay. So I would entertain a motion that we support this recommendation and that we forward it to our standing committees. January.
So moved.
Second,
Okay, it's been moved and seconded.
since we kind of, Michelle did a terrific job of
Yeah, it's great.
working with Representative Grad and myself and putting this together and really helpful.
It's great.
So the motion was to
Accept this.
accept the recommendation.
Accept
from-
this recommendation from our committee to the standing committees. This is our recommendation. Any further discussion?
It's complicated.
It's complicated. I don't envy you folks. I'm just gonna do a voice thing. All those in favor signify by saying aye.
Aye.
All those opposed? And I do want to also acknowledge publicly, I don't know if we can do it in the record, that the 3 senators who are on Zoom, Senator Baru, Senator Lyons, and Senator Parent do support this. But due to the rules of a joint legislative committee off session, they have been, for a variety of reasons, could not attend in person today, and therefore are not allowed to vote on this because of our rules, but they do support this recommendation. So I do want to note that publicly. So it would have been a unanimous vote of the Justice Oversight Committee of the members. Senator Hooker was not able to make the meeting, unavailable. So, boy, we're ahead of schedule.
I know.
What the heck do we do?
We take a few minutes and just talk about your next meeting.
Sure.
I didn't even know.
I know.
This one next, right?
Look at all the other things that we're supposed to be doing on our list.
Right.
Great, then we don't have to do it at the end of the day. I think we were just concerned that we weren't going to fulfill all of our duties, but we already know that Rule 74. Oh,
Yeah, can I just say, is I do think,
I mean.
but they're not
that was
talking to
pretty
each
simple.
other.
Yeah.
They're not talking to each other.
so did you want to have them, I mean, it seems as though in terms of, do you want to schedule them for a little bit of time,
Yes.
but ask them to talk ahead of time,
Yes,
not to work out all their issues.
yeah, figure out where the
right
issues
here.
are.
But I think y'all were all correct in that, I was not part of the justice reinvestment stuff, so I didn't work on that language, but it does seem to just be miscommunication and more kind of logistics and management.
Administrative.
And rather than, not that I'm saying that we couldn't maybe make a tweak to the language if there needs some clarification, but
I think we'd be supportive of making a tweak to the language. The question is it really necessary if they can figure out the administrative issues.
Right, I mean, like.
Clear to me what the tweak would be, because
That's what I was trying to figure out, Senator. I'm like, so a recommendation is, maybe the form should come from the court. Okay, we're gonna put that in law? I don't think so. I mean, those are kinds of.
The form needs to read a
maybe
certain way.
do we have to tell them that they have to follow the risk assessment?
Yeah. So we would need the courts, persons' rights, DOC, and I'm not sure about council of state governments. If they should be in the loop or not.
I think they should at least know about this,
Be
because this is really a
notified.
priority of, just as Senator Sure said, of justice reinvestment too.
It was part of their recommendation, and I
Yeah.
They spend a lot of time on it.
Yep.
So the requirement would be they get together first and come to us with a solution.
yeah, the three though.
Yeah. So that takes care of that. We have taken care, we're talking later on this afternoon about the deputy sheriff's
Yep.
duties and responsibilities. So that's one of our
Right,
requirements.
and can I ask you a little bit about, because we're trying to figure out how to staff this, or whatever, and there's no attorneys in our office that worked on any of this stuff, and so,
Deputies,
yeah.
they might have sent appropriations.
Right, so it's a JFO issue, and so I guess I can talk to them about, that, but there's a report required. I have a little anxiety about.
Right, and you reached out to
Having-
Becky.
Pardon?
You reached out to Becky.
I did, but
Watson,
she
and then
thought,
she reached out to me.
yeah, she thought it really wasn't her issue, and I thought it was a contracting issue, but.
Because what I said to Becky was what we're looking at is clarifying the deputies' responsibilities, their duties and their responsibilities.
They're statutory duties.
When they're paid by the state,
Okay.
okay, and when they're not doing transports,
Statutory duties when paid by the state.
right? But they're not doing the transports, they may be doing other state
But
functions.
also, how should they be organized?
Right.
I'm sorry.
Who, should it be, how should we do state transports? You've got three different agencies charging very different rates, as I understand it. One is DCF for transport of kids. One is the court transports, and the other is mental health transports. They're all, it's all within the Agency of Human Services, but you have different rates. Then you have sheriffs watching hard to place youth because there's nobody else that they can place them at, and that's a $663 a day charge by the sheriff. And then the question becomes, instead of having 25 deputies, state paid deputies under each sheriff divided up in 14 different districts, should there be one in the north, one in the south for transport? Should they be supervised by the Department of State's attorneys and sheriffs so that the transports are done? But what I've been concerned about, particularly in the auditor's report, is that you had a situation where the state paid deputies in Chittenden County for about 8,000 hours were at home getting paid during COVID. And you had the state contracting with the Lamoille County Sheriff's Office to provide security in Chittenden County for the motels. In Bennington County, you had the local Manchester Police Department doing its best to cover the motels while the two state paid deputies in Bennington County were mostly at home for like 1,500 hours. So if you read that, that's where my concern comes. So the sheriffs could put their state paid deputy out directing traffic for consolidated communications, getting paid, and it's a state paid deputy. Can they do that? Do they, and is there double dipping going on? Those were the questions that the auditor tried to answer. And I think that it's a relic to have 6 state paid deputies in Chittenden County and 2 in other counties. And when you're transporting somebody from Burlington to Bennington, does it make sense for the Chittenden sheriff to do that and come back empty? Who should be doing it? And that's what originated all this concern. But what we found out when I found out from the auditor that had actually happened, the state had paid Lamoille County to cover the motels in Chittenden County.
This is, yeah, I mean, the last time we talked about this, Senator, it was just the whole thing fell apart because
Yep.
nobody could agree anywhere on anything.
No.
And I appreciate your concerns and because it seems silly that we're only this big. We have 14 different bosses competing for the same state dollar.
So
Basically, that's what it's coming down to.
in Wyndham County, Mark Anderson has basically done the contract with DCF to transport. So he's at 3 o'clock in the morning is out, because he actually, the last time I talked to him about it was actually, I just gotten back from the transport.
You see, some of the deputy sheriffs have better relationships with some of those like P&P officers, the field officers, or, someone within DOC or someone within DMH or DCF, and then they can work it through. Then other counties and other deputies don't have those relationships. So it also comes down to that level.
So what can the legislature say when we're dealing with 14 different constitutional offices? How far can we go? It's an open question, I guess. Is how far can we go and trying to wrap our arms around the disparities from different parts of the state and office to office to office.
The state paid deputies, I think, came about in the 1970s when the state took over the county jails.
Mhm.
Yeah, it's all connected to when corrections. Unified.
But that's what I was
It's
trying to.
not in the,
Some of the transports are not related to Department of Corrections. So not all transports are people in custody. So the question is about the training, also about the training available for transporting folks with mental health issues or behavioral issues or other. So there's a lot here, both on the money side and also on the training and resources side, that multiple committees need to. It's a big deal, and it's a lot of work. So it opens up a lot of different little cans of worms. And it's Friday.
Yes, to get to our meetings next Friday, I think we need to figure out the testimony we hear today about the deputies, what we're going to make as a recommendation. And I think that would be work for next Friday. So that's what Michelle was kind of asking. To get to that point, we need to know where staff us.
To me, it sounds like Becky, because it has to do with kind of institutional kind of structure with regard to the contracting, the money, and where people go.
That she was thinking it was more Damien.
No, but I talked to Damien, and Damien's only role in any of this was about having something to do with state employee union contracts. To me, it seems so tangential to him, but it's mostly seemingly when you're talking about the state contracting with the sheriff's departments and other folks. And the money issue.
Well, the question becomes, are we going to allow this to continue in the current state? And personally, I think they should be all put under the umbrella of the state's attorneys and sheriffs. The state attorneys should have one person coordinating. The State Department of State Attorneys and Sheriffs should have one person coordinating the entire state paid deputy and the entire transport system for the state. It shouldn't, and the question is, do you need 25 state paid deputies in the state now, given the virtual nature of most of the arraignments today? The sheriff from Wyndham County is actually taking people from Springfield and bringing them back to Brattleboro where they are released.
Yeah, that's beginning to
Because
be their
they don't
role.
have enough people to take to Springfield.
Right.
So when you've got, those are some of the things, and I just question, and I don't know the number that we need, but this is an appropriations issue, and it's a government operations issue, I suppose.
Yes.
But we are identifying a problem. And that's what I was trying to do in the appropriations bill in this current fiscal year. And somehow it ended up with this committee to look at. And I
wonder if you had
apologize for
something
that.
to do with it.
Well, I did, but no, I didn't have to do with this committee. My goal is to just say, we've got 25 of them. There's 6, I think, vacancies right now. So do you need 25? That's the question number one. Question number 2 is, how should it be organized? Should it be under each sheriff to do what they want with their deputies? And then the sheriffs confuse it by, and they're correct. It's their vehicles. The sheriff owns the vehicles. And so how do we reimburse the sheriff for vehicles and so forth? But again, if you put it under the state attorneys and sheriffs, then you don't have that problem, or you put it out to bid to one of either the north and the south, or however you want, east, west, however you want to do it. There are a number of things that could be done. That's where so I'm not sure who this legislative council is. I think Stephanie Barrett is critical here from joint fiscal, because it really is a question of state funds. And the more we use virtual arraignments, the less we're going to need state paid deputies. So is there some other job that they should be doing?
Right. I mean, part of that role might be moving that
And
offender from that facility.
Senator Lyons spoke about the different transports.
Mhm.
Should it be state paid deputies rather than, just a deputy sheriff? How do you do that? Because the need is no longer as great as it was. And it's a relic from the 70s.
And a relic of county government.
And a relic of county government.
Yeah, I agree with you 100%, Senator. I think maybe it's because I haven't been so, embedded in this, that when we were having testimony, I'm like, what the heck? This is such an antiquated system that isn't responsive to the needs that we have now or the diversity. And I think, it's for those county sheriffs who have an entrepreneurial spirit, they benefit from it. I think that it's antiquated for us to say we have 25 state-funded positions. I think that we should be looking at what are the services that the state needs, and then how do those services get fulfilled? How many staff that takes, I agree with you. I think that should be with the Department of State's Attorneys and Sheriffs. And we need to decide, or the administration needs to decide, what do we need for the service? What kinds of service do we need? And I think we should get away from, frankly, funding a certain number of positions and say, we should be paying a certain fee that does include, a rate not only for the personnel, but for the expenses associated with filling that duty, which includes, vehicles and, office and stuff like that. But I think it needs to be totally rethought.
We tried to do that in the 80s with Cola Hudson.
So you hit it on the head, Representative Wood. It's follow the money, and it has been follow the money.
Mhm.
I mean, we have 25 transport deputies. We can't get enough deputies to go into the court system because it's not a very profitable part of the business plan of the county sheriffs. So they're backing out of that. Windham County, and there's one other county that Washington County.
Well, I think Chittenden County has, at the gate, they have sheriff checking people in and out, but there's the inside the building, it's privatized. And I believe Grand Isle County is just in a dispute over how many days their sheriff can provide service.
So it gets.
And I think Orleans or Orange or somewhere, there's problems now with court security that they're actually not able to, they're moving around. I can't remember which, it's in the kingdom.
But yeah, we have 25 state deputies.
State deputies.
For that, working.
And I will add that they're the lowest, I did meet with the state deputy, one of the state deputies from Chittenden County, very nice. And he explained that they're doing all kinds of other stuff.
Mhm.
And, but they're also the lowest paid state deputies. Deputy sheriffs.
So I think we have our work for next Friday. Would be trying to figure out, after we hear testimony today, to see what we're gonna end up reporting.
Right, and I will figure out, and maybe it's gonna be Amarin, GovOps and working with Stephanie or something, so, but I will figure, you don't need to worry about that, I'll let you know, and I'll loop in what the attorney who is appropriate for that.
But yeah, with all due respect, I really think it is an appropriations matter, because it really does come down to how we're spending state dollars. And I'm not opposed to having deputy sheriffs
This is
who provide transport and are paid by the state to do the transport. I'm just opposed to having, not having defined role anymore.
So I'm looking at our duties. here.
Right,
So
yeah,
the next one is having JFO report to us on criminal justice fines, fees, penalties, and surcharges. And
You have that
this afternoon.
I think the only other thing is this December 1st report coming from the training council and DOC. And I don't know where they're at and whether or not you could hear from them next week.
Let's see if we can. I know they're in transition so much, but let's just, if we could check that out. And see if they would give a preliminary report, maybe, if they don't have.
Yeah, is that something that Julie would check with them on?
Yes.
So,
Well, Julie, yes.
I can give you this, you can just kind of see what it is that they're required to, whoever the contacts are now for DOC.
Is it Heather? What was Heather's last name? Which from DOC that worked with Priya.
That was,
The head
that
of,
was Heather, but she's gone.
but she's with the Criminal Training Council.
Right.
And Heather, what is her last name? I can't remember.
The Heather that's with Criminal Justice Training Council is Heather Simons.
Heather Simons, that's who you'd want to connect with, because this is from the Criminal Justice Council, Training Council. And DOC would develop a proposal governing minimum training standards, compliant complaint investigations, and a process for certification and decertification. This is the bill we worked on in that session, my committee.
And our new attorney that will be starting next week is going to be working on police certification, law enforcement, those kinds of things that Bren worked on.
Okay.
And he will be starting next week, so.
Okay, so that one,
we moved him here on Friday.
So that, and I think that's the only thing that's left, right?
I believe so.
The next stuff, some of this other is for 22. So we do have a full agenda for next Friday.
Right, so it's gonna be the Rule 74.
Yeah.
And then it's gonna be, where are you going on transport?
Yeah.
And then it's gonna be the training. Is there anything else?
And something, again, we're gonna have to take a vote on. These are our recommendations, correct? So we'll have to make sure people can be in attendance next week.
It might be good, though, to have an update from DOC on their COVID, because I think we all just got notices about an outbreak in St. John.
St. John, 3 housing units, maybe?
Yeah, and given the staffing problems they're having, I really would like to at least have a few minutes to discuss the COVID situation in the correctional facilities.
Yeah, I don't think they just Pretty well talked down and it just keeps.
Yeah, actually, I was talking with Jane Kitchell on the way up about a different matter, and she mentioned that she had a meeting this afternoon with the Northeast Kingdom legislators with Mark Levine and Mike Smith over the spike in COVID in the Northeast Kingdom. But I saw an email from DOC about St. Johnsbury, and I didn't have a chance to read the whole thing,
I
but
think they have seven. They're doing more testing, but it's in 3 housing units that are side by side.
so I think we should really get an update on that. If we have time.
Be a good chance to see the new commissioner again.
So that should fill up our next Friday. Now it's before we take a break for lunch. Yeah, we're actually on time.
How'd you do that, Alex?
I don't know. After yesterday, I have no idea. After yesterday.
Today was brutal.
Happened yesterday.
Oh,
Well, I'll brief you on that. So we are done on YouTube.